Welcome to today's program titled Guidance on State and Local Paid Sick Leave and Paid Time Off Laws, Part 16, 2025 Mid-Year Checkup. At this time, all participants are in a listen-only mode. For those of you who are logged into the live web presentation, you are encouraged to submit questions throughout the conference by typing them in to the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down as it will not be reread and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer.
Great. All right. Thank you, Kate. Good morning. Good afternoon, everyone. Happy fifth day of summer. We have a wonderful presentation for you today. This is the 16th segment of our paid sick leave webinar series. We've been doing this for a number of years, covering usually at minimum mid-year updates like we have for you all today. There is a ton of ground to cover, coast-to-coast updates, many of which have happened in just the last month or two. Joining me for today's presentation are my colleagues, good friends, all members of our National Paid Leave Counseling Team, Marlon Duro-Martinez, Katie Graham-Perot, and Renata Walker. I'm Josh Seidman. It is great to be here with everyone today. Next slide, please. So as you'll see on our next slide, we have, again, jam-packed agenda, lots of ground to cover. We're going to start with a very brief national overview that I will tackle, and then we're going to kick off with the three big state developments in Missouri, Alaska, and Nebraska. We'll then spend a few minutes talking through the updates from this past winter involving the Michigan paid sick leave setup. We'll then go to a few different regions with multiple updates per region, starting with the local laws in Illinois, Cook County, and Chicago. We'll then jump out west to Washington and Oregon with their paid sick leave laws, wrap up back in the Northeast with Pittsburgh and Philadelphia and recent amendments for both of those, one of which is already in effect. And then I'll wrap things up with New York City paid prenatal leave and a quick shout out to New York State COVID-19 paid leave and a wrap up of what to expect in the second half of 2025. Next slide, please. And one more. All right, so this is our national overview. If you have joined us for any of the first 15 segments of our webinar series, you'll have seen this slide. We refresh it periodically for folks. As of today, June 2025, there are 58 paid sick leave PTO mandates in the U.S. That is a broad, sweeping term. Paid sick leave in this context means more than one type of law. It means paid sick leave laws, paid sick and safe leave laws, paid safe leave laws, paid time off laws, paid time off sick leave combo laws, public health emergency leave laws, COVID-19 paid leave laws, and paid prenatal leave laws. A lot. That is how we get to the total of 58. If you do the math across the other columns, those numbers will not add up to 58 total laws. However, multiple jurisdictions have multiple types of those laws that I just rattled off. New York State, as an example, has a paid sick leave law, a paid prenatal leave requirement, and as of still today, a COVID-19 paid leave requirement. New York City, with its new paid prenatal leave component, now has multiple as well, by way of example only. One final takeaway on this slide before we jump into our location-specific updates, and I turn it over to Katie. You'll notice in that states column, this is something that as I was getting ready for today jumped out at me. Since November 21st, right, we have Massachusetts highlighted in that column. So that's Massachusetts, November 21, 2024. So a little over, it's like 7 months and 4 days ago. We have had updates in 11 of the 22 states that are listed on this slide. That is half of these jurisdictions. That is a patchwork that is in flux, that is volatile, that is having changes and developments regularly, even for companies who are on point and updating their policies regularly, usually at the end of their benefit year. Now is a great time to step in and review and determine if updates are needed. As you'll hear from our team over the next 55 minutes or so, Many of these jurisdictions have had updates that have come online already or that are coming online in the next couple of months. And with that, I will turn it over to Katie.
Hi, everyone. Thanks for joining us today. My name is Katie Perot, and we're going to start off with a quick update about all the drama going on with the Missouri paid sick leave law. So this law was passed by a ballot voter initiative in November of 2024 and went into effect on May 1st. However, it has not been without a number of legal challenges, and we currently expect the law to be repealed as of August 28th this year. Next slide, please. So because the law is currently in effect, there's a number of key provisions that we wanted to discuss with you. And the first is that the employee threshold. The law applies to almost all private employers and all employees with a very few niche exceptions. Accrual began on May 1st or upon the commencement of an employee's employment, whichever is later. And eligible employees must accrue at least 1 hour of paid sick leave for every 30 hours worked. There's no cap on accrual. And regardless of the amount of paid sick time that's accrued or carried over, an employer with 15 or more employees is not required to permit their employees to use more than 56 hours of paid sick time in a benefit year, or 40 hours if the employer is a small employer. Next slide, please. You're probably familiar with most of the reasons for use. They track what we've seen in a lot of other laws, but at a high level overview, employees can use Missouri paid sick leave for illness, injury, or health condition of the employee or their covered family member, or for the medical diagnosis, care, or treatment for those medical conditions for the employee or their family member, closure of the employee's place of business or a child's school or place of care when there's a public health emergency in effect, to care for the employee or the family member when health authorities have determined that the employee or their family member can spread communicable disease into the community, whether or not the employee or their family member actually has that disease, and certain absences related to domestic violence, sexual assault, or stalking, provided that the employer or their family member is meeting a variety of criteria related to the absence, including seeking medical attention, services from victim organizations, counseling, relocation, or taking other steps for their safety, or seeking legal services, including participating in legal proceedings. Next slide, please. So just to kind of walk through the timeline of what has gone down with respect to this law, as I mentioned earlier, the law was passed by a voter ballot initiative in November of 2024, but shortly thereafter, in December, a group of Missouri businesses filed a lawsuit seeking to stop the paid sick leave law from going into effect. And they were essentially asking that the law be held unconstitutional. And while the case was playing out, the Missouri legislature also got to work on a bill to repeal the law. So the law was being challenged both in the Missouri court system and in the Missouri legislature. And on March 31st, just several months before the law was set to go into effect, the Missouri House of Representatives passed a bill that repealed the paid sick leave requirement. That bill then was passed to the Senate, but before the Senate had a chance to vote on it, the Missouri Supreme Court actually upheld the law. And that was only 2 days before the law was set to go into effect. So because no action to repeal the law had been taken by the May 1st effective date, the law did go into effect on May 1st. However, only 2 weeks later, the Missouri Senate then voted and approved the bill that repealed the law. And now we're waiting to see if Governor Mike Keogh of Missouri takes any action on the bill. The bill has currently been sent to him, and if he takes no action or if he signs the bill, it will go into effect, repealing the paid sick leave law effective August 28th of this year. Next slide, please. So, given that the law will likely be repealed in August, it leaves employers with some decisions about what to do. Um, Several practical considerations are that employees must be given provided paid sick leave from May 1st through August 28th. And then that leaves the question of, you know, do we continue those benefits into the next benefit year? Do we, discontinue benefits as of the August 28th potential repeal? And that's something that employers will certainly need to consider. And if employers are not providing the paid sick leave from May through August 28th, there's penalties for noncompliance that employers should also be aware of. These include a private right of action for violation, meaning that employees can bring a lawsuit regarding their paid sick leave benefits. And willful failure to comply with the paid sick leave law is a Class C misdemeanor, and each day of a violation constitutes a separate offense. Additionally, employers can be fined up to $500 a day for violations. So as you work through decision making about what to do between now and August, or what to do between August and the end of your current benefit year, you should consider these legal risks and measure them against practical considerations such as the looming and expected repeal, system challenges, working through your HR, and working, of course, with your employees from an employee relations perspective. So that is a short update on what's going on with Missouri, and I'll now pass it to my colleague Renata for an update on Alaska.
Thank you so much, Katie, and hello, everyone. As far as the Alaska paid sick leave law, we reported on this during our last paid sick leave webinar back in December of 2024. Like Missouri, this was a ballot initiative that was enacted late last year in November. And this new law is going to go into effect next week. That said, we are still anticipating some regulations forthcoming from the state, so there may be additional updates yet to come, but we wanted to spend the next several minutes just walking through some of the key provisions of the law, as well as some insights from the FAQs that the state has released this spring. Moving on to the next slide, as I previously mentioned, this is a ballot initiative going into effect on July 1st, next week. And there are some particularly noteworthy things in the FAQs, one of which is that one of the FAQs indicates that state law does not allow for the governor to veto laws that are passed by initiative, and the legislature is prohibited from repealing said laws for a 2-year period. So this means that unlike what just happened in Missouri that Katie was telling you about, the Alaska paid sick leave law is here to stay, at least for the next couple of years. In terms of the key provisions of the law, this law has very broad coverage standards, and the FAQs confirm that all employers in Alaska are covered. That said, there are certain enumerated exemptions for specific types of employees. In the interest of time, I won't list every single one of these, but most notably, these do include certain employees like minors who are under the age of 18 working fewer than 30 hours per week, and certain employees who are covered by a collective bargaining agreement if it contains a clear and unambiguous waiver. Covered employees must begin accruing their paid sick leave on July 1st, 2025, or upon the commencement of employment, whichever is later. Employees must accrue at least 1 hour of paid sick leave for every 30 hours that they work, up to a maximum of 40 hours a year for the small employers, which are those with fewer than 15 employees, or up to 56 hours per year for the larger employers with 15 or more employees. And there's no provision in the law about how to calculate employer size, so presumably all employees are counted regardless of whether they work within or outside of Alaska. The FAQs clarify that sick leave accrues on all hours worked, whether straight time, overtime, hours paid at different rates, regardless of whether an employee works some kind of alternative schedule, rotational schedule, or other non-traditional work arrangement. And salaried exempt employees will accrue based on a 40-hour work week unless their normal work week is less than 40 hours, in which case their paid sick leave accrues based on that normal work week. Now, this law has no provision addressing front-loading, meaning an upfront grant of sick leave in lieu of accruing based on hours worked. Given the law's accrual caps, it's probably pretty safe to assume that front-loading either 40 or 56 hours, depending on the size of the employer, on the first day of each benefit year is going to meet your accrual obligations, but there are still technically year-end carryover requirements. And if we go on to the next slide, we'll get into that a little more. So there is no cap on the amount of accrued and unused paid sick leave that employees can carry over from year to year. That said, regardless of the amount of paid sick leave that an employee accrues or carries over from year to year, employers can cap the amount of paid sick leave that an employee can use, and that can be 40 or 56 hours per year, depending on the employer size. The FAQs clarify for us that employers can offer employees the option to cash out accrued unused paid sick leave at year end, but this choice belongs to the employee. So if the employee wants to carry over their unused paid sick leave instead of cashing it out, they have to be allowed to do that. Employees can use their paid sick leave in the smaller of hourly increments or the smallest increment that the employer's payroll system uses to account for absences or use of other time. And paid sick leave must be available for employees immediately as it accrues. There's no usage waiting period. Employers are not required to cash out accrued unused paid sick leave during employment or at separation of employment, but if an employee separates from employment and gets rehired by the same employer within 6 months of separation, any unused accrued paid sick leave that they had on the books at the time that they separated will have to be reinstated. The law is clear that employers can use existing paid leave policies like a universal PTO plan for compliance with the paid sick leave law, so long as the policy makes available, the right amount of paid leave, that it can be used for all the covered reasons and under the paid sick leave required conditions. And the FAQs clarify that if an employee uses all of their universal PTO or their paid leave for non-paid sick leave covered reasons and then later needs paid sick leave for a paid sick leave covered reason, they do not get additional paid sick leave time. On the next slide, we'll just touch very briefly on reasons for use. These are pretty standard, the illness, injury, or health condition or need for preventive care of an employee or a covered family member, as well as certain safe leave reasons related to domestic violence, sexual assault, or stalking. The next slide will take us to our covered family members. These are pretty broad, but really fairly standard family members that we see in a lot of paid sick leave laws. Immediate family member here means the spouse of the employee or another person cohabiting with the employee in a conjugal relationship that's not a legal marriage, a child, and that includes a stepchild or adoptive child of the person, parent, sibling, grandparent, aunt, uncle, or a parent or sibling of the employee's spouse. Also covered under the law are domestic partners, children and parents related by foster care or legal guardian or ward relationships, and in loco parentis relationships, and any other individual related by blood or whose close association is the equivalent of a family relationship. The next slide will touch on notice and documentation. So when an absence is foreseeable, employees must make a good faith effort to provide notice in advance and make a reasonable effort to schedule the use of paid sick leave in a manner that does not disrupt the employer's operations. The law is actually silent about notice for unforeseeable absences. Employers can require employees to provide documentation to support their use of paid sick leave only after the employee has been absent for more than 3 consecutive work days. And the law defines the types of documentation that must be accepted. And also employers cannot require, specific details about the employees or family members, medical situation or health and safety information when they are requiring documentation. And on the next slide, I'll round out our discussion of Alaska with just an important quirk regarding employer notice requirements. So the notice requirement under the law is that employers must provide written notice of the following. at the commencement of employment or within 30 days of the effective date of the law, whichever is later. So first, beginning July 1st, 2025, employers are entitled to paid sick leave and the amount of paid sick leave, the terms of its use guaranteed under the law, and prohibition on retaliation. The FAQs provide us with a couple of pretty important clarifications. First, the notice period for current employees. The FAQs state that the plain reading of this language indicates that the notice period for current employees runs June 1st through July 31st this year. And second, perhaps more importantly, the state has said that it will not be providing a model notice. Now, there has been an update to the state's wage and hour poster to include some information about paid sick leave, but it appears that simply distributing that poster is not going to suffice to meet the notice requirements, and the FAQs state that employers must create their own notices. So that sums us up for Alaska, and I will pass the mic to Marlon to talk to us about Nebraska.
Thanks, Renata. So we're going to talk about Nebraska, which goes into effect on October 1st, 2025. And in the next slide, we're going to start with looking at just who this law covers. So as you'll see here, both employer coverage and employee eligibility standards are very broad. Pretty much all private employers are covered. There's only some exceptions for federal and other governmental employers. In terms of employee eligibility, again, very broad. It covers individuals who work in Nebraska for at least 80 hours in a calendar year, and individuals who are covered by the Federal Railroad Unemployment Insurance Act are not covered by the law. So very broad. And then in the next slide, we're going to see that the accrual rate for this law is pretty standard, just like most paid sick leave laws, at 1 hour for every 30 hours worked. Accrual begins on October 1st, 2025, or the employee's first date of employment if they're hired after the effective date of the law. The accrual is capped at either 40 or 56 hours per year, depending on the size of the business. So small businesses can provide 40 hours, and a small business is defined as an employer with fewer than 20 employees during a given week. If an employee has 20 or more employees for 20 or more calendar weeks, either in the current or preceding calendar year, then they have to provide 56 hours of paid sick leave. An employer can decide to forego the accrual system and instead front load this time to employees at the start of the year. In terms of carryover, there is no cap on carryover. So this means you have to allow employees to carry over any and all time to the following year. There is one exception, and that is if you decide to cash out the paid sick leave at year end, but you must also front load the time and make it all available in the beginning of the subsequent year in order to avoid carrying over time. So we'll see on the next slide that the annual usage cap sort of mirrors the accrual cap. So it's 40 or 56 hours, depending on the employer size. Increments of use. Now here you see we've included a provision from the law as well as the FAQs because there might be a little bit of a gray area here just based on the wording of the law and the FAQ. So the law provides that sick leave may be used in the smaller of either the hourly increments or the smallest increment of the employer's payroll system that the employer uses to account for absences or use of other time. The FAQs, however, is written a little bit differently in that it says employees may use paid sick leave in either 1, hourly increments, or 2, the smaller increment of time that the employer uses in the payroll system. So it makes it seem like there's an option to choose to do the smaller increment or the 1 hour increment. And it says that employers must allow at least hourly increments. Now, the safest reading of this, of course, would be to do the smallest increment that the employer's payroll system uses. But there is a little bit of gray area that we're hoping the regulations might clarify. In terms of usage waiting period, Nebraska follows a lot of the new laws, which don't have a usage waiting period. So that means the employee can use the time right away. In terms of balance reinstatement for rehires, Nebraska has one of the longer periods of time. So if an employee is rehired within 12 months since they were let go or otherwise separated, then you have to reinstate their paid sick leave balance for them to use. In terms of existing plans, we usually get questions, well, I already give leave to my employees. Can I use that? So the answer is that you can if certain conditions are met. So you would have to meet conditions of the law by providing enough time, providing, allowing employees to use it for the right reasons and under the right conditions. Reasons for use. So as you'll see here, there are 6 different reasons for use. I'm going to jump around a little bit here, but you'll see that most of these reasons for use are very common throughout most paid sick leave laws. So for the employee or covered's family, medical needs, diagnosis, treatment, care, preventative care, for closures relating to the employee's place of business or child school or place of care due to public health emergency, or for an employee to self-isolate or care for an employee's family member if either the employee or family member has a communicable disease and needs to isolate. So you'll see that here I skipped number 3. This is because it's not very unique to Nebraska, but it is one of the reasons that's not in every paid sick leave law. And that is that employees can use the leave to attend a meeting necessitated by an employee's child, mental, or physical illness, injury, or health condition at a school or place where the child is receiving care. So again, not unique to Nebraska. New Jersey, for example, has something similar, but we don't see this in many of the laws. So the next slide, we're going to see that the covered family members, it's also pretty typical of what you see in most paid sick leave laws, covering a child. It also covers the parent, a person who stood in loco parentis to the employee, grandparent, grandchild, or sibling of both the employee or the employee's spouse. It also covers the employee's spouse. And for all of these relationships that I mentioned, it covers both biological, adopted, foster, and step relationships. And of course, it has the catch-all covered family member that we see in many of the paid sick leave laws, which is any other individual related by blood to the employee or whose close association with the employee is the equivalent of a family relationship. So next slide, we're going to talk about notice of absence. So basically, just like most paid sick leave laws, you have to provide leave to employees if they make an oral request. Now, I don't think this means that you can't accept written requests. I think the law is just trying to say that an oral request is sufficient. But the important thing to keep in mind about the notice of absence provision in Nebraska is that there is a written policy requirement. If you expect employees to provide notice, then you must include it in your written policy. Otherwise, you can't deny the sick time for non-compliance with this. So next, we're going to look at documentation. And again, here, nothing unusual. It permits employers to request documentation for absences that are more than 3 consecutive workdays. The documentations are either something signed by a healthcare professional or the employee can just provide a statement written by the employee themselves. One important thing to keep in mind about Nebraska is that it does have an available balance notification requirement and requires that the following information be recorded either in or in an attachment to the employee's regular paycheck, and that includes the employee's the amount of paid sick time available to employee, amount of paid sick time taken by the employee to date in the year, and the amount of paid that the employee has received for paid sick time. The FAQs do provide that you can use an online system that employees have access to comply with this requirement. Next, we're going to look at the notice standard and the posting standard. So there is a notice and poster standard. Written notice has to be provided to employees at the commencement of employment or for existing employees by September 15th, so 15 days before the law goes into effect. There is also a posting requirement, and the poster has to be posted either in a physical place, or if there is no physical place of employment or the employee teleworks, you can use a web-based system. The requirement for the notice and poster is to do it both in English as well as in any language that's the first language spoken by at least 5% of the employer's workforce if the department has provided a notice. So unlike Alaska that Renata said is not going to provide a notice, Nebraska will provide a notice. Next slide, please. So the last thing we're going to look at for Nebraska is some of the provisions about things that employers cannot do. So employers cannot interfere with, restrain, or deny the exercise or any attempt by the employee to exercise their rights under the law. Can't require the employee to find a replacement if they're going to be out. Can't take retaliatory personnel action. So it is job protected, and employers cannot use an absence control policy that counts paid sick leave under this law as a reason to take action against the employee. And that wraps up our brief overview of the Nebraska law. And with that, I will pass it on to Michigan.
Thanks, Marlon. Hello again, everyone. If we can go on to the next slide, we're just going to talk about some amendments to the Michigan Earned Sick Time Act that took effect February 21st, 2025. So starting out, just to make sure we're all on the same page about the state of paid sick leave requirements in Michigan, I just wanted to walk through very quickly sort of the history of paid sick leave laws in that state. So back in 2018, the Michigan legislature approved a ballot initiative known as the Michigan Earned Sick Time Act, or ESTA. Later that same year, the legislature used an adopt and amend procedure to overhaul ESTA and essentially transform it into the Paid Medical Leave Act, or PMLA, which was sort of a more employer-friendly sick leave law. And the PMLA went into effect in 2019. The PMLA is the law that dictated paid sick leave requirements in Michigan for the next several years. But that adopt and amend procedure that created the PMLA was the subject of a legal challenge. And on July 31st of 2024, the Michigan Supreme Court issued its long-awaited decision in the Mothering Justice case, holding in a 4-3 ruling that the PMLA is unconstitutional and reinstating ESTA. So that resolved about 6 years of uncertainty as to the status of paid sick leave in Michigan. ESTA replaced the PMLA effective February 21st, 2025, but of course, Michigan had to keep things interesting, and they made some 11th hour amendments. So on February 20th, 2025, they amended this law. So the ESTA that we know today, as it's amended, looks a little bit different than what we were expecting as of the date of that Mothering Justice decision. So for the next several slides, I'm going to touch on a few key differences between the original ESTA and the amended ESTA that actually went into effect in February. And I just wanted to make it clear that this is a comparison of the two different versions of ESTA. This is not a comparison of ESTA to the PMLA, which has been the operative paid sick leave law in Michigan for the last 6 years or so. If you'd like more information about a comparison between ESTA and the PMLA, you can actually refer back to our December 2024 webinar in this series. I think it's part 15 of this series, where we kind of break that down for you. So if we go on to the next slide, we will start looking into our substantive discussion here. And I'll note at the beginning that the employer coverage standards under this law have remained very broad, even with the amendments. You know, generally any employer with one or more employees in Michigan is going to be covered by this. There are some reduced obligations for small employers of 10 or fewer employees. The amendments have narrowed the definition of employee somewhat, though the coverage is still pretty broad. Under the original ESTA, employee included anyone except federal employees. The amended ESTA keeps that carve out for federal employees, but also includes some carve outs for certain individuals who can schedule their own hours if the policy the policy prohibits the employer from taking any adverse personnel action against the employee if they don't schedule a minimum number of hours. Also some carve outs for unpaid trainees or interns and youth workers under the Michigan Youth Employment Standards. On the next slide, we'll touch on usage waiting period, year-end carryover, and front-loading. So the original ESTA had a 90-day usage waiting period. This has been increased to 120 days under the amended law. The original ESTA had no cap on year-end carryover, but under the amended ESTA, carryover can be capped at 72 or 40 hours, depending on the employer's size. And the original ESTA had no provision on front loading, but under the amended ESTA, you're allowed to front load either 72 or 40 hours, depending on the employer size, and that eliminates accrual and year-end carryover requirements. There is a proration of front loading allowable for part-time employees if an employer meets certain criteria. In the interest of keeping us on track, we have a lot of things to cover. I'm not going to get into too much detail on that. But as a reminder, the amendments did not change the accrual rate, which is 1 hour of paid sick leave for every 30 hours worked. They did not change the accrual cap. There is no cap on accrual, or the usage cap, which is either 40 or 72 hours per year, depending on employer size. But again, those topics have been changed when you compare ESTA to PMLA. And again, if you would like more information on that comparison, you can go back to part 15 of this webinar series, which we presented back in December 2024 and is available on our website. Moving on to the next slide, taking a quick look at notice and documentation. Employers generally can require 7 days advance notice for the foreseeable use of paid sick leave. This did not change under the amended ESTA. For unforeseeable absences, the original ESTA called for employees to provide notice as soon as practicable. The amended ESTA says either as soon as practicable or in accordance with an employer's policy if certain conditions are met. In terms of documentation, the general standard has not changed. Employers have to wait for an employee to be absent for more than 3 consecutive workdays before they can request documentation. But while the original ESTA simply said that employees have to provide their documentation in a timely manner, under the amendments, employees have to provide the documentation within 15 days of the employer's request. Moving on to the next slide, we will shift gears a little bit and take a quick look at some updates at the local level in Illinois, specifically Chicago and Cook County. So on the next slide, we will start with Cook. There have been some amendments to the rules in Cook County, first in October of 2024 and then again in April of 2025. So at a high level, the changes in October of 2024 required employees to accrue paid leave while they were using paid leave hours. That is a pretty unique standard. I think Rhode Island, if I recall correctly, is the only other paid sick leave law that has that type of requirement. The rules also prohibited employers from requiring employees to use paid leave, but clarified that employers were not prohibited from requiring an employee to use their leave in accordance with FMLA rules and regulations. And the rules also added some pretty specific written policy requirements. For example, employers have to have in their written policy an advisement to employees of their leave benefits and their rights, and you have to, provide that by the employee's start of employment or date of initial accrual. There were some specific requirements that had to be included in the written policy in terms of coverage and rate of accrual and permissible uses and prohibited practices and that sort of thing, and that had to be distributed to employees. So as far as the April 2025 changes, just to give you a little bit of background on that, the Cook County Paid Leave Ordinance was actually amended in March of 2024 to exempt school districts organized under the Illinois School Code and park districts under the Illinois Park District Code until January 1st, 2025. And so most of the changes that we saw to these amended rules in 2025 were related to school and park district employees now being covered. But very importantly, the amendments also removed that requirement for employees to accrue their paid leave while they were using their paid leave. So we're back to just accruing while an employee is actually working. And then if we can move on to the next slide, just a quick update on Chicago. There's a model notice that has been updated from the Office of Labor Standards. We have a link to that here. This needs to be posted from July 1st, 2025 through June 30th, 2026. Also has to be distributed to current employees and given to new hires with their first paycheck. And then as a reminder, there's a private right of action in the Chicago paid leave and paid sick leave ordinance. So there has been this cause of action available since July 2024 for the paid sick leave portion, but it's now also going into effect for the paid leave portion of the law. That's the leave that they can use for any reason, effective July 1st, 2025. So I think that wraps us up for Chicago, and I will pass the mic back over to Katie.
Hello again, everyone. So we have a couple quick updates on recent amendments to the Oregon and Washington paid sick leave laws. I know these laws have been on the books for a while. Next slide, please. So there's been two recent amendments in Oregon. And just as a quick overview, under the Oregon paid sick leave law, employees are entitled to 1 hour of paid sick leave for every 30 hours worked, and there's a 40-hour cap on annual accrual, usage, and year-end carryover. And as a reminder, front loading does get rid of carryover and accrual tracking requirements in Oregon. There are no paid sick leave localities, so we are just talking about the Oregon State paid sick leave law today. And the first of the two recent amendments was passed on May 14th of this year and goes into effect on September 28th. And this amendment just solidified some changes that we saw in the rulemaking back in 2024. And this change impacts the covered reasons for use. And the second change is an amendment that was passed on May 28th of this year, also impacting the covered reasons for use. And this change will go into effect on January 1st of 2026. So next slide, please, and we'll talk about these amendments in a bit more detail. So following the May 2025 amendments, the reasons for use under the Oregon paid sick leave law are for the employee or their family members, illness, injury, health condition, or preventative medical care. The reasons for use that are under the Oregon Family Leave Act or Paid Leave Oregon can also be reasons for use under the paid sick leave law. Those include care for an employee's child who requires home care, bereavement leave, bonding leave, including for birth, adoption, or foster care, for a family member or an employee's serious health condition, and safe leave. And these are the reasons for use that were codified into the amendments to the actual law as opposed to the rulemaking as of May 14th and go officially into effect on September 28th. But we anticipate that most employers were already allowing these reasons for use due to those rulemaking changes back in 2024. Under the Oregon law, employees can also use paid sick leave for safe time absences related to the employee or the employee's child being a victim of domestic violence, harassment, sexual assault, bias crimes, or stalking. To donate paid sick leave to a coworker if the employer allows, certain public health emergencies, and finally, the new amended reason for use that goes into effect on January 1st, 2026 is for an employee to take paid sick leave to donate blood. Next slide, please. So moving over to Washington, as a quick overview, in Washington, under the state law, employees are entitled to 1 hour of paid sick leave for every 40 hours worked. There's no cap on accrual or annual usage, but there is a 40-hour carryover cap. Differently from Oregon, front loading does not eliminate carryover and accrual tracking requirements in Washington state. There are several other paid sick leave laws at play in Washington. Those include Seattle, Tacoma, CTOC, and that CTOC is limited to only certain employers. So also similarly to Oregon, there has been 2 recent amendments to the Washington state law, one in April and one in May. And the amendments also cover the reasons for use. And the first that was passed in April goes into effect very soon, just about a month, on July 27th. And the second goes into effect on January 1st of 2026. So on to the next slide, and we will talk about those amendments in a little more detail. So first, the April 2025 amendment that goes into effect on July 27th now allows workers to use Washington state paid sick leave to cover absences from work to prepare for or participate in any judicial or administrative immigration proceeding involving the worker or their covered family member. And just as a note, this applies to both employees and transportation network company drivers in Washington state. Next slide, please. And finally, the second amendment to the Washington state paid sick leave law recently was passed in May and goes into effect on January 1st, 2026. And this covered reason for use now allows eligible workers to use paid sick leave to cover absences from work when they or their covered family member are the victim of a hate crime, including offenses that are committed online or otherwise through the internet. So just keep an eye out and make sure to check policies that your new covered reasons for use in Oregon and Washington state are included. And I'll now pass it over to Marlon.
Thanks so much, Katie. So we're going to talk about updates now in Pittsburgh and Philly. So if we can go to the next slide, please. So the Pittsburgh Paid Sick Days Act was originally enacted in 2015, had some legal challenges, didn't go into effect until 2020. And most recently, there were some updates that were passed on June 12th, an amendment to the Pittsburgh Paid Sick Days Act that goes into effect on January 1st, 2026. So the amendments impact employee eligibility. Under the amended law, all employees are covered. So there's no more requirement that the employee work at least 35 hours in a calendar year. The accrual rate is now faster, from 1 hour for every 35 hours worked currently to 1 hour for every 30 hours worked when the amendments go into effect in January. The accrual cap went up for both employers with 15 plus employees, from 40 hours to 72 hours. That's a big increase. That's 32 additional hours. And it also went up for employers who have fewer than 15 employees, from 24 hours to double that, 48 hours. And this impacted both the annual and the point in time caps. Next slide, please. So these numbers, of course, also impacted front loading, which again went up from 40 hours to 72 and 24 to 48 hours. And carryover requirement also increased to reflect those numbers. So important to make sure you get your Pittsburgh policies updated in time for January 1st. And with that, we'll go on to neighboring Philadelphia, where there's been a lot of updates when the Power Act was passed on March 27th, 2025, and went into effect immediately. It impacted a lot of different laws in Philly, including wage theft and domestic workers laws, but we're going to focus today on paid sick leave and retaliation. So one big impact on the next slide we're going to see is to the coverage standard. The big takeaway here, first of all, the new additions are in purple font, so that's how you can tell that it's new. But the big takeaway here is that the law previously excluded all employees who were covered by a bona fide CBA. However, now the law only excludes non-probationary employees covered by a CBA. So that means that probationary employees have to be covered and will be eligible for Philadelphia paid sick leave. Next slide. There were a lot of changes to the notice and posting standards. First, I want just a reminder that in the notice and posting, Philadelphia has always had this requirement where you have to include information on how to file a complaint. And the reason I flag this is because there's some additional information in the law now about when and how employees can file complaints. There's no updated notice or poster as of earlier today, so please make sure that you keep checking the Philadelphia website for information on that. One good thing for employers is that the law removed the handbook requirement, so you are no longer required to have your sick leave policy be part of a handbook, but you do still have to have a policy with that information. Next slide, please. So there is notice and posting specific violations and enforcement information under the law. The big thing that I want to flag here is that the civil monetary penalty is $2,000 for each violation, and it's no longer only for willful violations. And there's also injunctive and equitable relief for both former and current employees. Notice and posting is very, very important, and it has even broader implications. So if we go to the next slide, you can see that if you don't provide notice, that can allow an employee to toll the statute of limitations for the period in which they did not have notice of their rights under the law. But the worker does have the burden of showing that they are entitled to the tolling. Next slide, please. So there is a whole long section on retaliation, so we can't go over into very many details. That would probably require a webinar of its own. That's how long that section is. But just be aware that there are amended obligations for non-retaliation that extend not only to the employer, but also any person associated with the employer cannot engage in retaliation. Next slide, please. So for general violations, there is $2,000 for each violation that the agency can assess in civil penalties, as well as liquidated damages in a separate amount. Now, there used to be a cap on liquidated damages. There is no longer a cap, so that's a very important thing to keep in mind. Next slide. There is now also, there was a private right of action, but now employees do not have to exhaust administrative remedies. So they don't need to go to the enforcement agency first. They can just bring a lawsuit. They generally do have to provide 15 days to employers to remedy the harm, but that does not apply to claims involving willful misconduct. The statute of limitations is also now increased to 3 years. And lastly, on the next slide, some other things to keep in mind is that both record keeping requirements were increased from 2 years to 3 years, and that there's now a changed definition for tip workers and the method of calculating the rate for tip workers. So if you have tip employees, please be sure to check and make sure you're paying them correctly. And with that, I'll pass it on to Josh.
Cool. Thanks, Marlon. Hi again, everyone. Great. We've got just a few more minutes here to talk through an update that starts 1 week from today. That is in New York City. So we'll finish off in New York City and then the last few minutes on New York State and then our wrap-up segment. Next slide, please. So that cover slide was not a typo. It did say New York City paid prenatal leave. If you are thinking back to the beginning of this year, though, you might remember that New York State had a paid prenatal leave mandate that started. That is still in play. It is still in effect. It began on January 1st of this year. You can see a link to the website there. It is part of the New York State paid sick leave law. So it is not a standalone law. It is just a mandate embedded within the paid sick leave law. That brings a number of components to the New York State paid prenatal leave law that are part of the paid sick leave law. But a few of the highlights of New York State paid prenatal leave as reminders: it is 20 hours of paid prenatal leave during a 52 calendar week period per the statute. The FAQs clarify that the benefit year should really be measured based on the first time that the employee uses the paid prenatal leave, right? That should start the clock on the 52-week period. There's also guidance and language in the law that talks about this being a benefit, this 20-hour benefit that is separate from other leaves, other time off benefits that the employee receives. Next slide. So what New York City did, this was earlier this month, it amended its paid sick leave rules to add a paid prenatal leave component. That paid prenatal leave component basically stacks on top of the New York State paid sick leave requirement. So it seems not incredibly clear, but it seems more likely than not that this is not a separate 20 hours of paid prenatal leave in New York City, but rather a 20 hours. So it's not 20 plus 20 for 40, but rather a 20 hours that as long as the company meets the most generous conditions of the New York State and New York City requirements for paid prenatal leave, that the employer can keep them sort of contained within a 20-hour bucket of time for employees in New York City. You can see that this leads to some interesting questions for New York employees who are outside of New York City. Right? Does the employer extend more generous New York City conditions to those other New York State employees? What are the pros and cons of doing so? Can its system handle it? What about the windfalls? So those are some considerations that if you haven't been thinking through those in the last few weeks since these rules were introduced and enacted, you've got a week until they go into effect. I will point out that the enforcement agency in New York City is the Department of Consumer Worker Protection, the DCWP. They enforce the paid sick leave law, the Fair Work Week law, among other laws in the city. They are very proactive, very aggressive with their enforcement, and they know their stuff. So it is worth getting your ducks in a row on this mandate. Last couple of bullet points on this slide, you can see that the FAQs that were released for New York City paid prenatal leave don't allow for changing the decreasing other leave amounts to comply, nor does it allow employers to increase the paid sick leave allotment by 20 hours to comply with paid prenatal leave. And the FAQs do talk about that same sort of 52-week rolling period from the first day that the worker uses the paid prenatal leave. Next slide, please. So a few other notes. Number one, who can use the benefit? Still, it seems more likely than not under the state law, and New York City took a similar position that it is only the employee who is directly receiving the health care for their pregnancy that can use the paid prenatal leave. They do come out and also say in FAQs that employees who are not pregnant, who are not the pregnant parent, cannot use the paid prenatal leave to attend the other parent's prenatal appointments. All right, so we have that guidance. One wrinkle comes from that very bottom bullet point, the sub-bullet point on types of leave about the FAQ saying that the time can be used for fertility treatment. That led to some grayness with this topic at the state level as well. But at a high level, what can it be used for? Well, it's leave taken for healthcare services received by an employee during their pregnancy or related to that pregnancy, including physical exams, medical procedures, monitoring, testing, and discussions with a healthcare provider, as well as end-of-pregnancy care and fertility treatment. Next slide, please. There is a written policy requirement. There is 98% sure one under the state law as well, based on how the setup exists there. But for New York City, there is a very robust, actively enforced written policy requirement for paid sick leave. That has been extended to paid prenatal leave, and it has a lot of meat on the bone, a lot of procedures that are involved. The method of distributing it needs to be a method that reasonably ensures personal receipt. You can see there are different timelines for when the policy needs to be distributed to workers. It must meet or exceed all of the requirements of the New York City paid sick leave law and the rules that needs to be in the policy. And as you can see on this list, a number of topics are explicitly called out in the rules that must show up in that written policy. Next slide, please. There is also a balance notification requirement for New York City paid prenatal leave. The notice needs to be provided each pay period that an employee uses the paid prenatal leave. The content is the amount of paid prenatal leave used during that pay period and their total amount of paid prenatal leave still available for use in that 52-week period. Given what I mentioned a few minutes ago about the 52-week period and that it's going to be individualized for each employee, I can see that creating some system challenges for companies that are going to need to be worked through. Method of notice, employee pay stubs or separate written documentation provided each pay period is the gold standard, is really the way to go if possible. You can use an electronic system if certain conditions are met. Next slide, please. There is also notice and posting requirements and a new model notice that comes along with those requirements that covers both paid sick leave and paid prenatal leave in the city. There's a link here for your use. It needs to be posted conspicuously in the workplace, distributed to both new hires and existing employees in that latter group, likely by August 1st, right? That's the FAQs don't explicitly say that, but we believe that that is the date by when existing employees need to receive the notice, but really as soon as you can is the best practice. Again, deliver it through a method that reasonably ensures personal receipt by the worker, and you need to keep records of that distribution and receipt for at least 3 years. Next slide, please. And as if that wasn't enough, there is a ton of additional substantive requirements. Under the paid prenatal leave standards for New York City, we've been having discussions with companies about many of these topics and how they interact with their existing setup for New York State benefits and how their systems can handle the changes. Don't forget to compare each of these standards to the New York State standards when you are assessing. Our team is here to help. We're happy to help. Next slide, please. All right, one more, please. New York State COVID-19 emergency paid leave. It's been around since March of 2020, the very early days of COVID-19. It is the last one of these laws left in the country, and it is sunsetting in just about a month from now, a little over a month. Here's a nice picture of the sunset that I actually took from CyFAR's New York City office almost about 7 years ago. So great views. If you haven't been to the office, come on down. We'd love to see you there. Next slide, please. All right, our paid sick leave outlook. And before I jump into this, I do want to just read off the CLE code for folks. The CLE code is SS as in Cyfarth Shaw 5683. Again, that is SS as in Cyfarth Shaw 5683. One more time, SS 5683. All right, so quickly for the next slide, please. We will take a look at what's coming down the pike. Well, plenty of things that we've covered today, right? Lots of stuff that is starting up in the next month or so. Alaska, that customized model notice, the Chicago distribution of the notice, the New York City paid prenatal leave. Philadelphia is already in place. Washington State and its reason for use that Katie covered, that's already in play. So lots of stuff to get your arms wrapped around if you have operations in any of those jurisdictions. And then once you exhale and enjoy a little bit of the summer, we've got plenty more coming in August with the repeal, hopefully, most likely, of Missouri. And then we get into Nebraska and the year-end items. What could be coming next? New York City might not be done. Keep an eye out on New York City and possible PTO. We're looking at Delaware, Virginia, Hawaii, and Pennsylvania to potentially take some steps in this space, whether that'll be the end of this year or into the 2026 legislative cycles. That depends on how each of those states handle their legislative sessions, but definitely keep an eye on them. Next slide, please. So we have some CyFARth resources, go one more for me, that are available complimentary for folks' use. Most of them, at least, that is, we have a paid mailing list, paid leave mailing list for folks. You can sign up at the link there. We also have surveys available for subscribing clients that cover everything and anything in the paid sick leave bubble that we've talked about today or any of the other laws that are in place around the country. If you want more info, you can send a line to paidleave@cyfarth.com, and our team will be happy to get back to you. Next slide, please. We also have this webinar series available for folks. Again, part 16 today. You can see the lengthy list there. They're all available online, slides. There are recordings of most, if not all of them. I think a lot of them on YouTube, which is a little scary, but also very fun. I've had family members listen to them in the past and ask me about paid sick leave. You can also see we have a podcast called Take It or Leave It that I have the pleasure of hosting. We cover a ton of ground in the leaves and accommodation space, not just paid sick leave. Our latest episode, episode 41, dropped earlier this month, and it was a really great episode on best practices and pitfalls for managers and how best to train managers in the leave and accommodation space. Our next couple coming out, one of them will be on AI and leave considerations, so definitely stay tuned for that one too. All right, so with that, I think that brings us to time. I want to thank everybody for joining us today. Thank you for everyone who submitted your questions. We sent back a lot of responses to folks on those. Again, here is the CLE code one more time. You can scan it or I'll read it out for you. Again, that is SS5683. And with that, we look forward to seeing you at our next paid sick leave webinar, Part 17, coming later this year. Thanks so much, everybody.